Happy and good morning, all of you, and thank you for opting to watch my session online. On the occasion of inaugural ceremony of all five centers of Pixie Medicolegal, namely North Gujarat, Central Gujarat, South Gujarat, Saurashtra, and Kutch, I am sure the doctors of Gujarat state will get benefits of Medicolegal helpline as we concern with your medical legal issue. Today I am going to deliver oration on concerning medical legal matters. From the position of God in past to a service provider in present. So many laws have been framed for healthcare, and it is the duty of a doctor or healthcare to follow the laws because ignorance to law is not an excuse. So now let's discuss where the doctors or any healthcare is answerable. Doctor or healthcare can be dragged into criminal cases, civil suit, consumer forum, state medical council, or any other non-government organization. So, first we will discuss about the criminal liability. Rather than talking about cases or instances of criminal liabilities, I will explain how to deal with such cases. Now, recently the IPC has been replaced by the BNS, Bharatiya Nyaya Sanhita. And as per the BNS, Bharatiya Nyaya Sanhita, previously it was IPC. Mainly BNS 106 is concerned with the doctors and healthcare sectors. We will discuss about the 116 BNS. It was covered under 304A IPC, Indian Penal Codes, which defined the death by negligent act means healthcare industry was put in the category along with the other industries. In some cases, 304 IPC was applied. Apart from 304A, 304 IPC was applied to doctors also, where the provision of imprisonment up to 10 years was there. But when the BNS came into the force, the representation made by the Indian Medical Association to government made and BNS 106 came into the action, which addresses death by negligent act means whoever causing death of any person by doing rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of up to 5 years. But if such act is done by a registered medical practitioner, he shall be punishment with imprisonment of up to 2 years only, not 5 years. That is specifically for the healthcare industries or doctors. Means lesser form of the punishments. So now the BNS reduces the punishment for doctors framed under this section and if proved guilty and clarified that this section applies only for registered medical practitioner only. So, quack means unqualified will not get benefits of 106 BNS. Listen carefully, this is for the registered medical practitioner only. So, benefits of this section will not apply to the quacks, unqualified doctors. So, BNS gave some relief to doctors for not considering medical negligence at par with the other industries. Because in other industry, the imprisonment is up to 5 years. For healthcare, it is 2 years. And also mention the reduced form of punishment, but never excluded doctor from any criminal liabilities. So apart from the qualification of the doctor, need to follow principles and protocols of standard medical practice. So now question is, who will decide? Who will decide that a doctor has followed the protocol of standard medical practice or not? So, whenever any complaint lodged against any doctor under BNS 106, that is Bharatiya Nyaya Sanhita 106, police will start investigating the case. Police will collect the medical records from doctors or healthcare industry, whatever it is. Take statements of doctors and staff also. So, first thing is never fabricate the records. Only write whatever treatment you gave to the patient. Give meticulous reply to the police. Take help of medical person or lawyer, advocate, so who can guide or who can give the right guidance in writing or giving the reply to the concerned authorities. Police, after taking your statements and collecting the medical record from you, from doctors, from healthcare department, will submit all the papers, all the statements, all the records to district government hospitals. Head of such hospital will form the medical board, and who, after studying all papers, will prepare an opinion. If opinion mentions negligence of a doctor, then police will lodge the FIR against the doctor. Then doctor has to face court proceeding. So, without medical board opinion, no one can lodge the FIR against the doctor. And after the lodging the FIR, after the court proceeding, if the judgment goes in favor of the patients in the court of law during court proceeding, doctor has to face imprisonment too. That is up to 2 years of imprisonment as far as the 106 BNS is concerned. So first thing should be clear in your mind. Investigation by police doesn't mean you will be sent to the jail. As per the Supreme Court guidelines, doctor cannot be arrested for alleged medical negligence cases without taking medical board opinion. And opinion suggests negligence of doctors, then FIR can be lodged against any doctor for any alleged medical negligence cases. So if someone is lodging complaints against you in police station, that doesn't mean it is FIR. To convert complaint into FIR, police need medical board opinion of government hospitals. One more thing to draw your attention, that any alleged medical negligence cases always send body for the postmortem examination to know the exact cause of death. So remember, if any mishaps, any death occurs in a hospital, healthcare, doctor has to send body for the postmortem examination to know the cause of death. So these are the criminal proceeding, criminal act that we have discussed. This we have discussed in short also. Now coming to the consumer forum. Since the doctor are covered under Consumer Protection Act, so doctor-patient relationship is now service provider-consumer relationship. So any patient can drag doctor into consumer forum for deficiency of service. Consumer courts are step into the district, state and national courts. 3 step-wise, lower court, higher court, like that. Which is mainly based on the documentary evidence. So again, here, whatever documentary evidence are produced in the court of law, which are analyzed by the presiding judge and a member of that court. And after that, judgment is given for compensation. So, meticulous document is again an integral part of any treatment. Compensation mainly awarded, mainly depends on expenditure incurred, loss of income by patient. That's criteria are counted for the compensations. And once the compensation awarded to patients, doctor has to pay money, or he may opt to go to the higher court also. Again, in the higher court, the judgment goes in favor of the patients, then again the doctor has to pay the compensation with interest too. So, here message to all doctors to take the professional indemnity scheme. So, financial liability can be diverted to insurance company. In my practice, I observed that newcomers start their practice without taking professional indemnity. So, when any mishap occurs, newcomers, those who have joined the practice recently, so they may face such financial burden in their struggling period of practice. He has to earn the money, and meanwhile he dragged into some financial burden also. So, message for all doctors: first indemnify yourself, then start your practice. One more thing, that in consumer forum, doctor need to remain present Any authorized person or advocate can represent your case in the consumer court unless doctor called by the consumer court. Third one is patient can complain against doctor in state medical council. Here, when the patient makes complaint in state medical council, council give notice to doctor to send the written explanation in stipulated time. So after that, doctor is called in the council in person to make more clarification, and after hearing from both sides, if council reach to the opinion that you have violated the rules and regulations laid down by National Medical Commission, council may suspend the license of medical practice for particular time period of a doctor. So these are the places where doctor can be dragged. Sometimes you feel that you have treated patient very sincerely, even though you are dragged. So remember, this is professional hazards, and all professions are facing this. So rather than being nervous, deal it with confidence. So many a time doctor feels that all the laws are applicable to us only. Is there any law for the patients? The answer is yes. There are laws which applicable to patients also. If any mishap occurs to your clinic and relate to assault doctors or damage to the properties, then FIR can be lodged against the accused person and police send them behind the bar also. Sometimes after taking the treatment, the patients do not pay doctors. He can file the suit against him in the commercial court, and commercial court can reward him, and doctors can get that payment also. So there are also provision of false complaint in the Consumer Protection Act, which one can be penalized for the false complaint also. So these are the laws that is applicable to the patients also. So in summary, do ethical and fearless practice, treat the patient as per the standard protocol of medical practice, make proper and meticulous documentation, and lastly, the consult medical legal person or advocate, or in any case of mishap in your clinic or hospitals. Thanks for listening me on our Pixie Medicolegal platform. Thanks a lot.